Hello to all and good morning. I hope this finds you in good shape and welcome to our Bath Life Business Surgery with Mojas Druitt. I hope also that your loved ones and your teams are safe. The loved ones, if anything, even more so given the topic we're going to be talking about, which is very personal. My name is Greg Ingham and welcome to this Bath Life Business Surgery. We're trying to help businesses and employees in these tough times where it is not so straightforward to work out what is right to do in our personal lives and in our professional lives. These Bath Life Business Surgeries should help guide you in these very difficult times with practical advice and valuable insights, because we can all do with help. At this time, we need guidance on our decisions in the coming months and now, decisions which will affect our businesses, our employees, our city's economy, and today, decisions which will affect you and your families in years to come. Good luck. Before we get going, some news for you. So, following the sellout initial success, we held another Bath Life virtual wine tasting last night. Some of us apparently enjoyed ourselves quite a lot during that, with our partner Stony Street. This time it raised money for the Bath Bulls, and we will be making an announcement in due course quite soon about the Bath Bulls this year, so please look out for that. Also look out for a very special Bath Life Business Club on Monday. It's about the vital events sector in the city, which does so much to add to broadly the gaiety of nations, but certainly to the city's economy as well. Our speakers in that special event session include those from Theatre Royal Bath, Dorothy House's fundraising events, the Bath Half, and also Bath Festivals. Events matter hugely to the city, its reputation, its tourism, and all our enjoyment and so on. So that is a very important session, very interesting session. Many of you, quite gratifyingly, have been asking about the return of Bath Life and when we will recommence publishing. We haven't yet set a date. We will give as much notice as we can, of course. We want to come roaring back and to, as ever, celebrate all that is good, in fact, great about this city. And we have some big plans for that relaunch, which we will share with you shortly. However, if in the meantime you have time-sensitive news, such as businesses opening up, we've got some cafes such as this. Look, I've got coffee here. Cafes opening up already. Look out for the Bath Life weekly newsletter, which is out tomorrow and every Friday, going to several thousand Bath people who are keen to know what is happening in the city. And specifically, we'll have a retail special next Wednesday. Our doors are open as the city begins to open up for retail from June 15th. Amongst other matters coming, we're running a dispute resolution session with Mojas Druitt again, which is on next Thursday, June 11. You think of it this way, from leases to contracts, there's an awful lot of disputes brewing, again, as people, as companies are figuring out what their post-lockdown world might look like. We'll be running other business surgeries. They'll include such as recruitment and retention, IT and remote working, office fit out, especially COVID compliance, digital marketing, and there'll also be, we hope to line up a very special Bath Life debate about the merits of office versus home working. Today, it is about wills and inheritance advice, and we'll be covering anything from the rationale for wills and planning, the practical points, key aspects to consider, difference between business assets and personal assets, powers of attorney, guardianship disputes, intestate accounts, a role of independent trustees, opportunities for wills to be changed by surviving partners, much, much more. When you get into it, you go down the warren, the rabbit hole of this area. There are multiple iterations which need professional advice and careful planning. It is part of this series of the Bath Life Business Surgery advice sessions about how we all operate differently. If your business either has a need for professional advice, that's all of us, or has a service offering which you think would work in this environment, please do talk to us. We can provide that platform and help provide insights for all our benefits. This webinar will be available afterwards on the Bath Life YouTube channel. Many have accessed our videos previously, which is great, so please share it. It's becoming a repository of very useful information. So our two speakers today, I'll be interviewing from Mojas Druitt on your behalf, and we'll bring in questions during it. If you look at the button at the bottom of your Zoom screen, you'll see a little Q&A thing. I'll take those questions, and of course, particularly given this topic, they may well be very sensitive. We'll take those anonymously, of course. We'll be careful. This is a very private area, and I will explore on your behalf issues which arise. Our two speakers today, if we could bring them forward, they can bring themselves forward. David Hill, many of you will know David as a partner at Mojers Druitt, head of the private client team. He has over 30 years experience of working in estate administration and specialises in complex estates, estate planning, lifetime gifts, tax mitigation, and he's a member of the Society of Trusts and Estate Practitioners. Additionally, Luke Watson. Luke is a dispute resolution partner at Mojers Druitt, head of the Wills and Inheritance Dispute Team. He has over 20 years experience of both property and commercial dispute resolution and specialises in contentious probate. Luke is a member of two associations, the Association of Contentious Trust and Probate Specialists, ACTAX, who knew that? And he's a member of the Property Litigation Association. So if we could start with David and about Mojers Druitt as a company. David, welcome.
Good morning, thank you.
Good morning. So how's lockdown been for Mojers Druitt? What have you been doing and doing differently?
Everything has been done differently, I suppose. From working from home, which is something that I really hadn't done an awful lot of. Video calls, client contact, not face to face, but well, face to face in a way, but virtual. So yes, we've obviously been going through risk assessments recently as we hopefully get just a return to some degree of normality from an office. But I think that the feedback we're getting from staff is that a balance between working from home and in the office is what they're looking for, and that I think we're embracing and welcoming, because I think it works all round. It's good for all of us, so long as the IT works, which we find out most of that pretty quickly. So yeah.
Would you mind not jinxing the session? As soon as you say
sorry,
bad is going to happen. But tell us this: how's the team been bearing up in these times? Because there are pressures working from home, and particularly if you perhaps lack, if not the equipment, but the locale in which to be able to work from home.
Yes, it is different for all of us. I mean, you know, I have a young family, and as much as I enjoy spending time with them, it's not always the best atmosphere to be concentrating on. When that's happening, homeschooling is far more of a challenge than I thought it would ever be. I will never badmouth a teacher again. But no, for some, I say one of the things that as a firm we're quite proud of is that we're very close as teams and as a wider firm, and that's something we've encouraged and engendered over many years, and we've lost an awful lot of that. Just because we're not in the same room as each other, not seeing each other in the same way. So yes, we've had Zoom quizzes. I'm not the best quiz master, but that's something else that we need to learn, and that's helped. We've had some of the staff coming in from time to time because we need to pick up documents and papers, so we aren't beginning to see each other, but yes, as I say, with the return to work, I think that there's lots of areas about whether it's from how do we get into the building to who's allowed to use the fridge.
You'd think that lawyers would be amongst the best and smartest looking at what is the
program. We're good at writing lots of documents, but yeah, not sure we're good at following instructions.
I have absolutely no doubt of the former, query the latter. In very brief, do you have a week, a month when Mojers Druitt might be back in office?
No, we're actually having a firm-wide Zoom call tomorrow to invite questions, much the same as this format, not we've stolen from you, Greg, so that we can gauge the feeling from the staff, how they want to work it. We've still got to adhere to the regulations, and whilst we can do that with most of the offices, we won't be returning to full staff until this is over, really.
Two things for you and all others. To reiterate the point at which your companies are back, we can help promote that through our Bath Live channels. And the other, we really are keen on this, the great debate about the merits and demerits of working from home as well as in office, which affects, give or take, all of us. Thank you for that for the moment, David. Let's bring in Luke. from your very much the disputatious Luke. So you're in the more contentious, not disputatious, more contentious areas.
I'm not sure if that's a word, Greg, but it sounds. but I like it. I might start using it if you haven't copyrighted it. It's
you again as a lawyer, you would know about copywriting. It's yours if you wish it. But how's lockdown been for you?
For me personally, well, similar to Dave. I mean, I probably was used to working from home more regularly before lockdown, so I had sort of the tools that I needed to do that. Simply, perhaps because the type of work that I do is slightly different. And I suppose if I needed some quiet time, I would often work from home before lockdown. The main difference now, of course, is when I would come home and work, I wouldn't have my 3 children at home at the same time, which is obviously makes it different. And my wife also working full time from home as well. So I think it's not so much home working that's been difficult and more challenging. It's home working in the current environment, and of course also not having the downtime, the ability to pop out, particularly during the beginning of lockdown, pop out for a coffee or go out in the evening for go meet some friends. So you don't have the social downtime, which I think we all need, and I think is important as a way of getting away from the the pressure that any job creates. But in terms of working from home per se, it's quite a productive way of working, actually.
Good. I want to come on to one of the things which people have been thinking about during this lockdown time, which is, frankly, thoughts of mortality. With the 50,000 more, and it'll keep rising deaths in the UK, people are thinking about their own personal destinies. And I'd like to bring David in on this point about wills. And why do wills matter? It's as basic as that.
I think the easiest way to answer that is that it makes life and, ironically, death easier if you have one. Doesn't have to be complex. Just something that's straightforward can have a huge and positive impact at a time when it's tough, and that doesn't even scratch the surface of how things like this can affect a family. And it's quite stark, I think, the difference between having a will and not having a will in some circumstances. We do have legislation which tries to provide an average will outcome for an average family, but I'm not sure that an average family really exists now. We are dealing with legislation which is the best part of 160 odd years old. Wills Act 1837. It's the intestacy rules get updated from time to time. They have been recently, but still not really keeping track of today's world. Just as an example, you can have quite a standard family unit these days, which maybe consists of a couple who are unmarried or not in a civil partnership, have children together, but they're not recognised as related for inheritance purposes. And that can cause all sorts of problems.
We will come on to some of those difficulties. And just as you're saying, the 1837 Act, if you want a sort of case study, what it might mean in practice, I would recommend reading Bleak House if you haven't already, because it's all about...
There you go, absolutely. Yeah.
Jarndyce v Jarndyce, an extraordinary case in terms of wills. But tell me this, do you think wills are mattering more in lockdown, that there is this sense of mortality and so on? Are you,
I think it's one of those things. I mean, the stats still speak for themselves in that, so around about 60% of the adult population that haven't made wills. And that doesn't really tell us the full story, because you can make a will from the age of 18, and obviously as you look at the stats for getting towards the age of 50 plus, the percentage is slightly lower, around about 40. But it's still, I think we take lots of risks by not having an unnecessary risk. Mortality is something that none of us like to think about. Wills are funny things, really, because you don't get anything from your own will. You can tick it off the to-do list, but it's rarely going to get to the top of the list. It's right up there with root canals, but I think it can give a sense of relief of having done it. As I say, it doesn't have to be complex. And a simple will has a longer lifespan almost. It's difficult to argue against having one rather than having one.
When you say it's not complex, just talk us through in brief the process of going from a thought I ought to have a will to happening.
It starts with just a good discussion. From my point of view, it's never my role to tell someone what to put in their will. My role is to listen to them, understand their circumstances as best I can, and then give some advice and guidance and maybe a few what ifs. But it is that story which is the most important part, because in one way you want to start with the end goal. Where do you want to end up with this? Where does your family want to end up with this? And then work back to the best solution. And the complexity of personal circumstances will dictate to some degree what the will looks like. But in broad terms, people have a fairly good idea of what their aim is. For some people, it's harder. Ironically, if we see someone who has very simple circumstances but has been single for all their life and has no direct family, they're often the people that it's hardest to help and create something. But often, the people that the automatic intestacy rules just really don't take account for.
Give us a steer, if not literally perhaps what you charge. You can if you wish, but generally speaking, what is a sort of reasonable cost of a not necessarily wholly complex, but a reasonably well structured will?
I think if you're going to expect some proper time to tailor something to you, you're probably looking at somewhere around the £300-400 plus VAT mark for stage one. If you have very complex circumstances, I think you need to expect that's going to be different. And that, as I say, it's not a small amount. And one of the effects of lockdown for all of us is that there are financial pressures that we didn't know we were going to have on the 22nd of March. The flip side of that, and I don't want to turn into a salesman here, but we insure our cars, we insure our houses and even our lives year on year, and spend probably a fair amount of money doing all of those things. And you're only covering one small part of your asset base. A will is something that not only protects the assets that you probably worked pretty hard to get, to be honest, but also is making life easier for those that are going to be left if something should happen. And I think if you put it in context, that's not a huge cost.
No, but what would you say to those who say, well, you know what, I can Google wills, I can get something off the shelf or off the net, and that will suffice.
I'm not going to badmouth that, because it is perfectly possible and feasible to do it, and there should be more than one way of achieving this. You shouldn't have to come through a professional. What I would say is that thank you for reminding me that I've been doing this for 30 years, but I started life in the probate registry. And that's where all of the applications for grants of probate when someone dies come. And by far the biggest issues that we had with wills that didn't have the effect that people were intending were homemade wills. And you can make a will for 20 quid. You absolutely can, but you're going to get 20 quid's worth of will. And I think that's quite a risk, if I'm honest.
In a sense, you're bequeathing a problem to subsequent generations, your loved ones and beneficiaries, potentially.
I think it's a false economy, and it might be worth bringing Luke in here, because I suspect that a good deal of the contentious issues that we have are based around wills that and this is the other thing as far as the law is concerned. Wills are very literal documents. You read it as it says, and we all use language in very different ways, and quite rightly in some circumstances, as lawyers, we are accused of creating words for the sake of creating words. That's to follow the format that we have as far as legislation is concerned, is to make it work. You and I can have a discussion, or what it's like when you send an email. you can intend the message to be something, it can be read completely differently. And with the law, it's even more strict than that. We have, this literal rule: you read what's in front of you. Even if you can see the overall intention is something different, you can be stuck with something that doesn't really work.
Well, let's take your suggestion and bring Luke in. Luke, perhaps you could just talk through, if not chapter and verse, because there's obviously client confidentiality here, but an example of where an imperfect will, not necessarily a cheap one, but an imperfect one, has subsequently caused great contention, which either you've acted on or are aware of.
Yeah, absolutely. I mean, I think that just picking up on one point that was raised just now by Dave in terms of the costs of a will, and as Dave was saying, the cost of drafting a will is not insignificant, but it is insignificant if you compare it with the amount of money that parties can spend arguing about a disputed estate or a disputed will. And we're where costs routinely run into tens of thousands of pounds.
Talk through an example of a contested will, or at least a contentious case that you directly know of, perhaps.
Talking about homemade wills, I suppose, but one of the most interesting cases I dealt with was a homemade will, which was left in a suitcase in a telephone box, and a call was made to the local police station saying that there's a suitcase with a will in it. This is a real case. It's not. I'm not making it up. It sounds like something from a crime story. And it was a homemade will on a bit of paper. It was different handwriting on the bit of paper, but it appeared on its face to be a valid will because it was properly executed. Anyway, in the end, there was challenges brought in relation to this will because they were concerned that it was a forgery. A forensic handwriting expert had to analyse the paper and the ink to determine whether it was a forgery. On a balance of probabilities, it was a forgery. There were high court proceedings, tens of thousands of pounds worth of costs, and that's one example. I could give countless other examples, but it just shows that if the best way to draft a will, I mean, it is better to draft a will professionally. I'm not just saying that because I'm a solicitor, but it is because if you have a professionally drawn will with evidence on the will file that the solicitor has explained to the person drafting the will what they're doing and what the effects will be, then the court will give that evidence great weight. And so with a homemade will, you don't ever tend to have the evidence that surrounds the intentions of the person drafting it.
Yeah, the context and intentions. Thank you. I'm going to bring in our good friend Anonymous, who's asked this question. I have a will already, but the details in it need updating. What do I actually need to do next? This is perhaps for David.
It depends what the updating details are. If it's something as straightforward as changes of address, if there are family members in there that have married and have new surnames, there's no actual need to amend a will. That isn't an integral part of it. If there are minor amendments, you can create a second document called a codicil, which is an addendum. But there can be, ironically, pitfalls with that too, because if you have a will that's flawed, making a codicil reconfirms those flaws. I think it's not necessarily that starting again, but I think reviewing the thing as a whole rather than just picking out the changes are useful. But yes, you can either make a new one, you can have a codicil if it's minor changes, but if the alterations are simply circumstantial because names have changed through marriage or addresses have changed, there isn't any need to actually change the will.
It may well be to do with personal circumstance, because at life stages we have different priorities perhaps, and we'll come on to some of those.
Yeah. I mean, there are, sorry.
I was going to move on, if I may, to the difference between joint wills and placing assets in a trust. What are the pros and cons, and as insofar as you can give general advice, which would you recommend?
I'm going to give you a proper lawyer's answer now. It depends.
Which is a benefit to our listeners.
Joint wills, I mean, first of all, there are two types of joint will. You can have wills which are mirror, And that just means that a couple are making wills that have similar terms and similar outcomes. You can have something called a mutual will, which is effectively a contract between two parties to make a will and not change it, and the survivor is then bound by the terms of that first will. It can be useful in very, very limited circumstances, but they can cause far more problems than intended. And you've referred to a trust, and it again depends where we put the trust. You can have a trust that starts when a person dies, so the trust is a trust in waiting and contained within a will, or you can create a trust during your lifetime to move assets into it for a second purpose. And there are many and various reasons why people do that. It can be based on family circumstances. It can be sometimes tax planning. It can help with having your cake and eating it, if that's a right way to put it. So what people quite like to do in wills is do two things with one asset, which is often quite difficult. If I give you a tenner and say, don't spend this on gin and tonic, I know you wouldn't, but you know, once you've got it in your hands, it's yours. I can't tell you what to do with it once I've given it. A trust is a bit of a halfway house where you can say, I'm putting this money into this place, the trust. I want the trust to do this with it during my surviving spouse's lifetime, and then I want it to go to my children. A simple sort of example, but you know, there are ways of retaining some control over where things go in stages, and then, you know, that can become complex, and if it's in the right place, it's the right thing to do. We see more of them with mixed families, as you can know, that is not uncommon at all.
Yeah, and trusts would typically have independent trustees. Is that the case?
Yes, I mean, there's no restriction on who can or can't be trustees, but you do run the risk of creating a potential conflict, because if you have trustees who are also invested in some way because they are beneficiaries, I don't think any of us would be able to separate ourselves in our own minds with a different hat on if we're making decisions about an asset that we may at some point become a beneficiary of. That can be difficult even at the best of times, but you know, personalities can play a big part in that. Independent trustees can be helpful as almost like a referee to ensure that the overall intention when a trust is created is followed. And often when we create trusts, we do ask clients just to write a side letter to say, I've done this, my thinking behind this is this, and that is what I'd like my outcome to be. And the trust is a vehicle.
And this may specifically apply to the next point about business assets. Are business assets inherently different from personal assets in any material way?
Again, the perfect law's answer, yes and no. They're assets as far as the estate is concerned, but they have certain characteristics that may make them helpful to pass on in certain ways. Some business assets will have tax advantages attached to them. There may be business assets that you want to pass on for succession purposes. You know, there's many layers as far as business assets are concerned. If it's a family business, there will be other connotations as to why you want to pass it to certain people or how you want it to be managed. And say then there's a tax angle to it too.
We'll come on to tax and gifting and inheritance in a moment. I just want to ask a specific question. We've had a couple of specific questions. One is this: is the process in any way any different if one of a partner is suffering from a terminal disease, such indeed as COVID? If you know that death is imminent, does that change in any way legality or process?
The process remains the same. There was some discussion at the very early stages of the lockdown as to whether there would be any changes to the law to allow us to make wills where we didn't have to use the same formalities for witnessing. There's also discussion about whether we could make wills by video. Some jurisdictions, Australia I think being one of them, have video wills which are acceptable. I don't think the wheels of our justice system turn anywhere quickly enough to allow that to happen. And now it was mooted, it was discussed, it's gone away. We haven't had any changes, and that's thrown out some practical issues, obviously during the lockdown, about how do we do it. And we've come up with some quite innovative ways of doing that because we can't see clients face to face.
Okay, a couple of specific points from two attendees. One, how does a letter of wishes impact the original will? Does it override the will, supersede it in any way?
No, a letter of wishes, a will has to have the formalities of the will to make it effective. So it needs to be signed, it needs to be witnessed, it needs to be dated, and it needs to cover what's there. A letter of wishes won't be seen as a testamentary document in the eyes of the law. We do often see is a letter of wishes in conjunction with a will if it contains any powers which might be discretionary in some way. So if you have a trust where trustees have some leeway to decide how and when to deal with the assets within a trust for a group of beneficiaries, the letter of wishes, it can't be binding on the trustees because then it defeats the object of the discretion. But it is guidance, and you would normally find that trustees will follow it, provided, again, going back to your first, one of your points earlier, Greg, is that you have trustees that you can trust with a small t.
Yeah, good. And how often should a will be reviewed? Is it, I don't know, 5 years or whenever there's a significant life stage change, or?
A bit of both. I mean, if there's any changes to personal circumstances and the ones that are sort of quite common to if you have children or grandchildren, you might want to review then. If there's a divorce or a breakup, either for yourself or within the family, you might want to look at that. And if someone dies, or the other side of it is if you inherit and your asset base changes significantly. For a lot of people, they may make a will that almost irrespective of their circumstances, the outcome will be what they want. I want my partner to have first take a bite of the cherry, and then I want my children. And sometimes reviewing it just to be reassured that what you've done already is fine is a good idea. And I would say, certainly look at it at least every 5 years. Sometimes we have calls from clients who've made wills which may be relatively straightforward, and they pick up the phone and say, David, we made this will 4 or 5 years ago. We've had a look at it. We think it says what it should, but we can't remember the discussion about the legalese that's in there. Can you just reassure us? And we have those conversations very, very regularly. And that's just a reassurance to know you've done the right thing.
You're clearly navigating very personal circumstances and personal decisions. I'm more particularly thinking in terms of couples here, but would you advise someone making a will to let the beneficiaries know in advance, i.e. when they're still alive, what the outcomes are? Well,
that's a very tricky one, because if a will changes, you've immediately got disappointed beneficiaries, and we all have families and we all have lives that are complex, and very little stays the same. I think beneficiaries is probably something that we would suggest that there's caution before you do. I think with executors, and the executor's role, like trustees, is to carry out wishes that you've included in your will or your trust. I think it's always a good idea to have a chat with them to say, I would like you to be my executor or my trustee. Are you happy with that? Because if they throw their arms up in horror, you need to look for someone else. So I think those discussions are sensible. But as far as beneficiaries are concerned, you can create a disappointment in advance, and that I think, that could be tricky.
So could I unpack that? Suggest that all equates to no. Don't do it.
You'd never get, I could have been a politician in another life.
You could well have been. Tell me about this. When people are thinking about their estate, sounds like a rather grand term, but all of their assets, howsoever. How would you advise people anticipate later life care costs, which, because we're typically all living longer, our care costs are going to be a more material part.
Yeah.
In one way, it's one way to spend the kids' inheritance. So how do you build that into thinking when it comes to wills?
Yeah, it's become quite a topic for us. It's almost taken over from inheritance tax, which has some changes there, which have lifted lots of people out of the tax band. But it's I think if you see it plainly, it's another attack on family assets. It can be quite emotive because planning to protect against care fees can almost have the impression that you don't want whoever's left to have decent care. I think that's not what the intention is at all. And it can seem rather mercenary, because if you're trying to avoid fees being taken from family assets, where they're going to come from, and you rely on a local authority. There are some measures you can take to try to protect. A simple trust in a will can be effective. To say, go back to having your cake and eating it, you can provide for a surviving partner within a trust, but those trust funds don't get means tested if care becomes an issue after the first death. Lifetime gifts or transferring assets out can be a method of protecting against care fees, provided the reason you're doing it isn't to protect against care fees. We have the same regulations that allow local authorities now to investigate what's happened to assets, as we did back in the mid-90s and prior to that, when funding was centrally through what was then the DSS and income support.
Could I just clarify that point? So you didn't quite say this, but is there a potential for an audit trail to go back into assets to see how they've been distributed? If
absolutely, yeah. I mean, it's quite. There's been stories about this in the media from time to time, but essentially, if a local authority, now for us, Baines, is left to pick up the tab for care fees, and they think that funds have been drained from a person's assets to avoid that, they can effectively use the same powers that you would under tracing assets in bankruptcy to find out where those assets have gone, and if it can be shown that those assets were moved out to avoid them being used for fees, they can be traced to the person that's received them. So,
talk about other assets. In current times, assets are very volatile. You know, what is the inherent worth of anything, most particularly when it comes to index stocks and funds and such like? Is there any sensible advice, or is it simply it's an asset which has rises and falls, has whichever value, and so be it?
You're probably asking the wrong person. You might need a financial advisor with that. But it's the same. It affects all of us in some ways, whether it's pension pots, investments, whatever it might be. And timing is everything, isn't it? You know, if you were forced to realise everything now, you're probably going to take a fairly big hit with both property and investments, and that can be relevant for estates. Someone that passes away now, you know, we've still got a volatile market for both property and investments for the foreseeable future. I think, you know, we are in a recession. How deep that goes, none of us know. I might pass on that one and say if you're thinking of should I liquidate or not, that might not be one for me.
All right, a different question. This is probably more for Luke. When someone dies in intestate, I think that's the term, when there isn't an extant will, what is the process for the valuation and sale of a key asset such as property? Who can effectively force that through?
Well, if you have an intestate estate, then rather than having the executors who are appointed under the will to deal with the estate, you would have administrators, which would normally be close family members who would effectively step into the shoes of the executors, and they would administer the estate in the same way as executors, really. There isn't any material difference between an administrator administering an estate and an executor. It just means that the executor has their power from the will, whereas if you don't have a will, it's a little bit more convoluted and you know, perhaps could be more complicated. And you might have arguments between family members as to who should be administering the estate potentially.
I'll come on to an area of dispute, or at least anticipated disputes, in a moment. I just want to bring in another anonymous question. This person says they've lived abroad for most of their life, and have estate assets, stroke pension, etc., and possible inheritors abroad. How does it impact a UK pension? Oh, sorry, a UK will, not pension.
Shall I pick up on that one? You can make a will in any jurisdiction as long as you adhere to the rules in that jurisdiction. I think that the question might be leaning towards a concept called domicile, which is where is home for you at the time that you die. And that can be quite different to residence. Domicile is almost a state of mind. Where do you consider home to be? So the answer is you can make a will to cover worldwide assets, and that's not a problem. Practically speaking, it's not always easy depending on the jurisdiction where those assets are. Being slightly empirical about it, if it's a former colony, there are arrangements that we have with most of those jurisdictions where documents produced here can be ratified in those countries. I think the best advice would be is if you have substantial assets in any one country, it might sound a bit heavy, but make a will in that country because it will make life easier. Even from a practical point of view, you can have executors based in England, but if you've got an asset in another country, the practical issues of dealing with it, I think, are paramount there.
On the point about the practical way of anticipating problems and dealing with them in advance, I want to move on to another area of what people are calling life admin that many are doing during the pandemic, such as power of attorney. If you could just briefly explain the rationale for that and maybe some of the complexities, what, when, why?
Okay, I think the best comparison I've ever come up with for a lasting power of attorney is like an insurance policy. You rely on it if you need it, and you ignore it if you don't. But you need it in place before you need it. Wills are great if you've actually died, and there's a lot can happen to us between being healthy and not being here at all, and that can relate to illnesses, accidents, age, and the issues that come along with that, and also just pure choice. And they are quite a good practical solution to issues surrounding our financial and personal lives that we can use to pass that responsibility on. We have lots of clients who have powers of attorney who perfectly capable of managing their finances, but just decide they don't want to. And they want to pass that down to the next generation and say, can you look after this for me? I'll tell you what I want to do. You use the power of attorney as a tool to do it. It's almost like an open letter of authority. In
brief terms, David, could you explain this? If you have granted power of attorney to your kids or whatever, at what point might it become valid? In other words, if you're reasonably active in your 50s, 60s, whatever, is the power of attorney even relevant? Is there some sort of definition of senescence or incapability that?
Yeah, it's and there's two layers for power of attorney to come into effect. First of all, when it's being made, before it can be used, it needs to be registered with a section of the court called the Office of the Public Guardian, and then it's valid. And there's no reason why it has to be used at that point. It can remain dormant and gather dust in a strong room somewhere. That's fine, and be pulled out if it's needed. As far as capacity is concerned, that is a medical decision. And the thing about illness, particularly things like dementia, is it's rarely a black and white question. There can be a huge grey area. Where you can have someone who has a diagnosis of dementia but is perfectly capable of making certain decisions, but more complex ones they may not be able to. So you have quite a hybrid. The Mental Capacity Act, which created lasting powers of attorney, tried to counter that by simply making 5 quite straightforward statements within every power of attorney document, which the crux of which is, if you're acting for someone as an attorney, you must do what's best for them, and that is the underlying message for all of those documents. You can't have a personal interest. You have to act completely separately to what you might want to do. It's what's best for the person you're acting for.
How early is it sensible to put in place LPAs? For example, would it be at the point at which a child reaches 18 or some legal maturity? Is that a logical trigger, or is it simply just there is no inherent reason just to not let it run?
I think the second, really. I mean, you summed up quite nicely. Is a bit of personal housekeeping. And in the same way, it's sensible for us to have life insurance. It's also sensible to have a power of attorney. It can be quite important, particularly for people who run businesses. You can have a situation, and we have seen it, unfortunately, where people are. Age doesn't really matter. Life is what it is. Thankfully, most of us get to our 70 before anything drastic happens, but that's not always the case. Illnesses, accidents can happen to all of us. If someone's running a business, even if they are sidelined for a fairly short time, and they are the only person that's running that business, there can be no option. And sometimes we've seen businesses fold because there's not that second layer of, if this happens, who can stand in and help?
Can I bring in Luke on that point about disputes specifically over LPAs, but really about how assets are run in the event of any ambiguity? Can you just talk about an experience you've had in that area?
Sorry, Greg. In terms of a dispute regarding if you have a dispute relating to assets or power of attorneys.
Yeah, there is a dispute around the authority of that power of attorney or its remit that somehow then inhibits action being taken on business assets. Is that something that you previously?
What often happens with powers of attorney is that, generally speaking, they are normally drafted by lawyers. Therefore, they are normally valid. The disputes tend to arise about whether the individuals who are acting as attorneys for the individual are fit and proper persons. So, for example, you could have a situation where certain family members are acting as the attorneys, but other family members possibly, say there's brothers and sisters, and say one particular sibling is an attorney and another sibling isn't, you can often have disputes about what the attorney is doing and whether they should be the attorney, and they can get quite nasty and quite personal, and that can then feed into, if there is a business, then obviously that would then feed into a dispute in relation to the business itself. That's where I see the tensions arising generally, is in relation to the people who are appointed and whether or not they are the correct people.
One sensitivity, which I'm sure you've each encountered, perhaps more David, is if an increasingly elderly person doesn't wish to grant power of attorney. That's quite difficult to navigate those discussions. But ultimately, if an individual, maybe with dementia cutting in or whatever, but if an individual does not wish to, there is no means of, quote, forcing through an LPA. It's got to be at their volition, presumably.
Absolutely, yeah, it's a completely voluntary document. There is a court process called deputyship, which is an alternative to lasting powers of attorney, but much the same as when we're talking about wills. It's far more cumbersome, it's far more expensive, and it's quite impersonal. So you can have a situation. What the ultimate situation is, that the court appoint a deputy, which is similar to an attorney, but the court dictate what happens and when. And if you have a situation where there is no power of attorney, but you might be acting on behalf of a spouse or a parent, it's quite difficult to think, okay, before I can make this decision, I need to ask someone at the court who's never met me or anyone else if I can do it, getting permission to do almost what you want with your own things. And as I say, it's cumbersome, it is expensive, and it's very, very slow. It's extremely safe because it's very slow. It's not helpful.
Dare I just offer, from a personal perspective, the deputyship process is one to avoid if there is any way of doing it. It's a bit of a mare, to use a non-technical expression, but there we go. Let's come on to, there's a question we've had from, obviously, again, another anonymous person. Deeds of power of attorney, what's the differences between the original ones and the current ones? deeds of power, right? I don't actually recognise the term, so perhaps you can
Yeah, no, I think probably what they're referring to is enduring power of attorney, and that was replaced by lasting powers of attorney in September 2007. Enduring powers of attorney.
Say the date, please, perhaps.
So yes, September 2007 was when we changed from one to the other. Any enduring power of attorney that was created prior to that date is still valid. We're finding that some of the financial institutions don't recognise them anymore because people hadn't seen them. The restriction is that with the enduring power of attorney, it simply only covers finances, and that's where we see primarily powers of attorney being used most. But lasting powers of attorney, there are two types: one for finance and one for health and welfare. You can mix and match. You don't have to have either or both, but an existing enduring power of attorney, if it's correctly completed, is still fine.
We're coming to the last 10 minutes. So some quick questions here. This is a complex one, but please be precise if you can. When it comes to gifting and taxation planning, when, why, what are the limits?
From my point of view, I think the primary question is, can I afford to give it away? And if the answer is yes, then there are less reasons not to do it than there are, because there are limits of £3,000 per year. The upshot is, if you, let's say, someone wants to give away £50,000, way over the annual limit, that's not an issue. There's no immediate tax consequence of making the gift. It sits in your estate currently for 7 years, or alongside your estate value-wise for 7 years. If you die within 7 years, it's treated as part of your estate, and it eats into your own tax allowance. Now, the flip side of that is, if you decide not to make the gift, you will still have that £50,000 in your estate anyway. The gifts are sometimes put forward as a bad thing to do if you're going to go with the annual limit. I take a different view on that. I think it's more to do with affordability.
Right. But to put it another way around, if you think, it's a complex area, if you think you're going to live more than 7 years, now is the time, if you can, to be gifting. Is that what that equates to?
Yeah, well, yes, but as I say, if you decide not to make the gift, then the tax is going to be there because you'll hold the asset and it'll probably be worth more. Maybe not at the moment, but in 7 years' time. There was a suggestion going back to July last year in a very boring paper that is from the Office for Tax Simplification to reduce the 7 years to 5. That's not come to anything yet, but watch this space. But I think the principles will still be the same. If you're looking to make a gift, often it's to help someone, a family member, go ahead and do it if you can afford it. And that's a difficult question because who knows what the future holds.
Yeah. Luke, if I could bring you in on this one. There have been a number of high-profile cases over the years about apparently peculiar bequests to charities, where family members are uniformly appalled to discover that some, cats and dog charities got all their lovely parents' money and they've got very little. What experience have you had of that, of those charity bequests actually complicating family dynamics and thereby being disputes?
A lot, actually. It's a very common situation, unfortunately, and it particularly happens where there are children who, for various reasons, have become estranged from their parents. There was a very kind of well-publicised case in the last couple of years, which is maybe what you're thinking of, where a lady, Heather Illett, had an estranged daughter. She was left out of her will and everything was left to the RSPCA, and it resulted in years of litigation and ended up going to the Supreme Court and costing horrendous amounts of money for everyone. So they are common. What children can do in those circumstances, if they've been effectively disinherited, is they have the ability to potentially try and bring a claim under a statute called the Inheritance Act. Is a 1975 piece of legislation, so a bit newer than the Wills Act of 1837, but still perhaps in need of reform. And that allows children to bring claims against the estates of their deceased parents. Those type of claims are quite complicated, and there's lots of factors that go into the mix. But in in summary, those type of claims are common. I mean, I'm dealing with a case at the moment on my desk where two estranged children have been disinherited from their mother's estate, and everything is going to some national animal charities. So it's a very real thing. It happens all the time, and I've very regularly dealt with cases involving those type of issues.
In some ways, a decision over will allocation, for want of a better term, is amongst the most personal, even sort of almost existential decisions one can make, such as charity bequests. I mean, are there, in either of your experiences, have there been some very peculiar bequests where you've looked at them and thought, really? But,
yes,
because that's the client for you.
Absolutely. I mean, sometimes, for example, the case I have at the moment, for example, is a case where the charities, apparently the mother who's passed away never had any connection with those charities at all. So the children are saying, this doesn't bear any resemblance to our mother. Why on earth would she have left these charities money when she showed no interest in them during her lifetime at all? But you're right, it's extremely emotive, because actually what happens is, if you are a child and your parents have disinherited you, even if you've had a difficult relationship, I think it hurts quite deeply. I think the individual's concerned, because it's a very profound sense of being left out, and the fact that it's perhaps a sign for the child that their parent didn't actually love them, and that they've, and that's pretty fundamental to the sort of relationship between parents and their children. So the feelings that are brought to the fore in these type of disputes are extremely powerful and deep-rooted, and that makes dealing with them particularly, you need to try and be particularly sensitive, if you can, as much as you can be, in dealing with these issues, because they are, as you say, very profound.
Very profound. Can I just ask you, as an individual, how do you navigate that? How do you navigate those contentious areas, particularly, as you say, around disinheritance issues? It must be especially complex for you. It
is difficult. I think the key is, and whether this is the right way, I don't know, but the way I personally deal with this is to try and be as professional as possible. So obviously you have to be sympathetic, but also you have to explain to your clients that ultimately your job as the lawyer in these type of issues is to try and resolve the dispute for them, and try and make the situation better, and not be part of the problem, which means not getting involved in the emotion yourself, because otherwise you will simply be feeding the sense of injustice and unhappiness that your client has, and that will not help them in the long run. You need to try and take a step back and approach it as a lawyer, because that's what the courts do. The courts will have sympathy, but they will decide cases on the legal issues before them.
Two last questions from people on this call. One is, what is the role of the executor of the will versus the power of attorney? Is there a tension point there?
No, they're often mixed, but one stops when the other one starts. Power of attorney is only effective during lifetime. Executorship is only effective after death.
Right, that's clear. Thank you. Forgive the very last observation here, but where should a will be best kept for safekeeping? At home? With Moges Druitt? They actually say that. That's the way one of your team said.
Under the floorboards. This is that we do have a flaw in the system, is that we don't have a central registration for wills. So it is quite feasible to write a will, get it signed, and stick it under the bed, and no one will know it's there. We keep many wills for clients and for people that have, whether they've made them with us or not, in safekeeping. Going back to one of the questions you raised earlier, should you tell everybody about the will? Probably not everybody, but going back to the executors, if you tell them, I've made a will, something happens, they will at least look for it. And we also suggest, when people make wills with us, let them know that it's here. Don't tell them what's in it, because it might change, but make people aware you've made one and where it is.
Very good. Our hour is over, so I would like to call to halt. Our thanks to Moges Druitt today, and to David, and to Luke. Thank you very much. There's one comment come in from Andy Clark, who has said, and I think this is fair, certainly on the latter point. Thank you to the organisers and participants. Very informative. Indeed, it has been very informative. Thank you all for your time and your questions today. Do look
Thank
out
you.
for our next Bath Life Business Club on Wednesday. I do the event special as mentioned with Bath event special as mentioned with Literal Dorothy House, Bath Half, Bath Festivals and so on. There will be another Bath Life virtual wine tasting event in favour of the Bath Bulls. We'll run it with Stony Street again. Please look out again for our business surgeries. Next one is also with Motors Druitt on dispute resolution. Other business surgeries to recap: recruitment retention, IT remote working, office fit outs, COVID being COVID compliant, digital marketing, and a special Bath Life debate on the merits of office v home working. If you have an interest in that, please contact us. We all need help navigating here. And yes, this is a tough time, but yes, this too shall pass. This has been a Media Clash production, and this has been the third Bath Life Business Surgery. Thank you. Bath together.